Hello and welcome to the first video about the Occupiers Liability Act 1957. I'm going to try and go through the first stages that we need to consider when we're looking at claims under the Occupiers Liability Act. So there are basically four things you need before you can show that there is a duty, and these are an occupier, a lawful visitor, premises, and that damage was caused by the state of the premises. So the first thing is who qualifies as an occupier under section 1 subsection 2. And in Wheat and Lacon they confirmed that although you can have more than one occupier, the key issue to consider is who has control. The person that has control will be the occupier. This was also confirmed in Harris and Birkenhead, as here the council were held to be in control even though they weren't actually physically living in the house. And this was because they had served a compulsory purchase notice. So they were going to be buying the property and they had control over it. So in a scenario, what you have to identify is whether the defendant is an occupier. And the way you do it is by saying they have control over the property. It's not about whether they own it or rent it or live in it or don't live in it. It's about whether they have control. So the second issue is identifying a lawful visitor. And there are a number of ways that someone could be a lawful visitor. They can have express permission, which means someone has verbally or in writing given them permission to be there. They can have implied permission. They can have a legal right of entry, like meter readers and the police, or they could have a contractual right. So, for example, a ticket to a cinema would give you a right to go into the cinema and you would be a lawful visitor. Lowry and Walker considers a little bit further what implied permission means, and in that case the defendant knew that the claimant was taking a shortcut across his land but did nothing to stop him. And this meant that the claimant had implied permission because the defendant knew about it and didn't do anything, and so it meant that the claimant was a lawful visitor and the 1957 Act applied. So in a scenario you need to identify that the claimant is the lawful visitor and then say why. Have they got express permission, implied permission, a legal right of entry or a contractual right? Note that there is no duty owed if you are not carrying out activities authorised within the terms of your visit. This means that you have exceeded your permission in some way. You're doing something that you shouldn't be. So Lord Justice Scruton said, when you invite a person into your house to use the stairs, you do not invite them to slide down the banister. So in a scenario, look out for someone who comes into a shop, say as a lawful visitor, but then goes through a no entry sign or a locked door. They've then exceeded their permission and become a trespasser, and they'll be dealt with under the 1984 Act. The third thing you need to look at is what are the premises under section 1 subsection 3. Premises include fixed or movable structures, including vessels, vehicles and aircraft. They have been held to include these two things. So in Wheeler and Coppass, held to include a ladder, and in Hazelden and Dorr, they were held to include a lift. So in a scenario, you're just going to identify what the premises are. Is it the house, a garden, a shop? Whatever the premises are in question, you identify them. And then the last thing that you need to consider is that the occupier's duty is in respect of damage caused by the state of the premises. There must actually be something wrong with the premises rather than the person doing something wrong on them. So in Ogwu and Taylor, there was a fire, but it didn't result from the state of the premises. It resulted from how a blowtorch was being used, which started the fire in the first place. This was negligent, so the claim should have been made under negligence, not under the Occupiers Liability Act 1957. So in a scenario, you need to note that the duty is only in respect of damage caused by the state of the premises and then identify what it is. So, for example, it might be that the floorboards are rotten and someone's fallen through them. That is something that is actually wrong with the premises, the house or whatever it is, and you need to identify it. So, to summarise, if you have an occupier, a lawful visitor, premises and damage caused by the state of the premises, then you are going to have a duty owed under the Occupiers Liability Act 1957. And so this is how you will start every answer on the Act. Here are the cases that we've talked about so far. See if you can identify them and remember the first 4 stages. Thanks very much, and I'll be continuing this series of videos about the Occupiers Liability Act 1957 by moving on to consider what the nature of the duty is and when you can be held to have breached it. Thank you.